judges come from Connecticut to be on the Second Circuit, and I'm very familiar with the Second Circuit. West Virginia, Maryland, the District of Columbia, North Carolina, Illinois, Indiana, Alabama, Florida. I know from the Bill Budrow case that the judges in Florida are no good. Mississippi, Jackson, I know it to be no good. Oklahoma City, I know that to be no good. Kansas, we could go across the whole United States, and I will show you these states where I have sued judges. And I don't have time to sit down and keep the exact count. But I know that I have filed 1,188 legal papers. I do have a record of that. Where were we? Norgo should be sued in small claims for $150. Consumer fraud. I paid him to do a job, justice. He didn't do it. Glendora spent 100 hours and $300 on this case and was cheated every inch of the way. It's too bad not to make the Chatham cheaters, that would be George Dixon, Joanne Dixon, Village of Chatham, Police Department of Chatham, Nasty Natalia, Brat Sister Lydia, Mother Marie, Father, Brother Carlos, Preferred Country Properties, and their lawyer, James Kleinbaum. It's too bad to make them not go through in an appeal. And this is dated August 16, 2001, or 2004, Anno Domini, the state of New York. And the mailing list is Norgo, the clerk of the court, Glendora TV audience, and Glendora internet audience. You are the most important. Orrin Hatch, Senate Judiciary, House Judiciary, George Bush, the administrative U.S. courts, biggest laugh, McDermott, American Patriot, Washington, D.C., and the Center for Judicial Accountability Incorporated, Elena Sassar, American hero, national hero. Is that all? Oh my goodness. Let me see. Let me go around and look at the camera. I think it's time for jokes. Well, I don't think we're taking much of a chance to say that it's time for jokes. That isn't jokes. Well, it is in a way. Those are the people I talk to on the telephone. Here's another card. Let's see if that's jokes. Oh, the jokes got lost. You remember the jokes that I was telling you? I have new jokes. Wait. There's another place they might be. I have to get internet tape number 12 and internet tape number 13 up onto the internet. I'd like to do that today. But look at all these legal papers. Did you notice what happened here? Did you notice? No. It was implied, but it's here. I'm not going to sue Norgo. He's the lead defendant in Omnibus 23 as I was writing it. But I don't think I'll file Omnibus 23. I think I'll save that $150. And I think I'll save that 50 hours. And I think I'll save all that postage and printing. And it saves the trees. Because you TV and you internet, you don't require trees. Paper. And think of all the labor this will save. This is the change that you and I have discussed now since last Sunday night. A week ago Sunday night. that we will present to these people what they have done against humanity and against the United States. We will present this, and against the world. We will present this on TV and on the internet, instead of suing. And of course you sue, and the Seventh Circuit is going to put you through all kinds of foolish hoops, all of which are obstructions of justice, about getting the appeal filed. And then of course the judges on the Seventh Circuit, the three of them, are going to do the same thing that Norville did, okay? Beat up on America. They're going to do the same thing. Betray the United States of America. They're going to do the same thing. And that's going to cost $255, they think, although that's illegal. It can only be $105, and they should be sued for that. But instead, we'll present it on the internet. So I tried to find the jokes that I lost. That's next week's joke. It was kind of funny though. About the man who took a course in speed reading. Now he moves his lips faster. What's the difference between a Xerox machine and the flu? A Xerox machine makes facsimiles and the flu makes sick families. And a man was strolling along the beach, and he picked up a seashell and he put it up to his ear, and a voice said, "Why aren't you working, you bum?" It was his mother-in-law. And Charlie had a way of saying that he took a half-a-year cruise, and his friend told the truth. He was sent up the river for 6 months. And I decided that I give very good advice. People never come back for more. And Pat is very happy that he sold the house he lives in for $450,000. The landlord's not very pleased. And somebody asked Claudia, "Why do you always take your paycheck to the bank?" And Claudia said, "It's too little to go by itself." Marilyn says that she's been depressed and miserable for years, but now she's turned that all around. She's miserable and depressed. Oh yeah, Paranoids Anonymous. Peter wanted to go to a meeting of Paranoids Anonymous, but they wouldn't tell him where they held the meeting. And Hazel says about her son-in-law, he's like a blister. He always shows up after the work is done. And his little boy and his dog, they used to go to school together. And they were inseparable. They would go to school together, then after school they'd come home together, and everybody thought it was so cute. But then one day, the separation came. The dog graduated. Is there anything else to tell you? Okay, you have in mind the 4,000th the chat with Glendora. How are we going to celebrate it? This might be a very good celebration, right? Stop giving courts money and having them steal it from you and not having them do the job. That might be a good way to celebrate it, right? Okay. Okay. We gather together to ask the Lord's blessing. He hastens and chastens his will to make known. The wicked oppressing now cease from distressing. Sing praises to his name. He forgets not his own. I'm always forgetting to tell you something before I get it ready to mail off, but this is the crazy appellate term, 9th and 10th Judicial Districts in Brooklyn. You know, remember that informa pauperis application that we worked so hard on for the appellate term? We said it would be a significant paper because it gave me a chance to tell the appellate term that Peter Lane in the Rye City Court did not do what the appellate term order told him to do when I won on the remand. I won on the remand and I won on the reversal. So I made this application because the minutes are $1,300, you know, and who can pay $1,300 for minutes? So I asked them to pay for it. I told them I could pay $150. And it really isn't informa pauperis because I did pay my filing fee of $30, so that was an IFP. All right? And so that's sent it back and said you served it yourself, you have to have somebody else serve it, and you didn't have your signature notarized, your affirmation notarized, making it an affidavit. State courts are so far behind federal courts. So finally, this is it. And Bonnie was nice enough, Bonnie Sutherland was nice enough to notarize it for me in 3 places. I asked her to go have a bagel with me, but she couldn't. And she didn't charge anything. Thank you, Bonnie. Well, folks, that motion for the appellate term to buy the minutes for $1,300. I got into the United States Post Office, for which I have great thanks. And I mailed 2 copy cartridges. And guess what, folks? It costs over $5 to mail 2 empty copy cartridges. Parcel post used to be reasonable. And then I went to the bagel shop. And it's an old-fashioned shop, and it doesn't have any curtains at the windows. They have nice, clean, great big windows that go from the floor to the ceiling. Old-fashioned shop. And I had a bagel. And I asked the church secretary to go with me. That would be ecumenical, right? And I saw the minister, and I handed in a program that's been cablecast to the church. They said they wanted one for file. And then I went to Berkshire Telephone, and they were very nice. Sutherland was very nice. She notarized that paper for the informa pauperis for the appellate term. Isn't she nice to do that? 3 copies. You know, the state courts are so far behind the federal courts. I mean, do away with this stuff, this notarizing. Just notarize my signature to the affidavit. Notarize the service. Federal court, you don't have to do any of that. So, came home and did the 5th legal paper out of 9 that came in Wednesday. 4 to go. And so here it is. It's to the United States District Court for the something District of North Carolina, Eastern District of North Carolina, Raleigh, North Carolina. And it's Glendora versus Clavert. Clavert. He was bad enough. But Norgal comes along and he's worse. Clavert in Milwaukee and Norgal in Chicago. But that does it. Thank heaven. I don't have to sue any more federal judges. Instead, I just go before you and tell you what they did wrong and let you decide and let you rule and order. Okay, this is written by a magistrate, James C. Deaver III, and it says the clerk has notified the court that the plaintiff's verified complaint received on July 14, 2004 was accompanied by a $150 filing fee. Because the plaintiff's filing fee was not processed, her complaint was not filed, and the court ordered plaintiff to pay the filing fee or to submit an application to proceed in forma pauperis. To correct the error, the clerk is ordered to accept the plaintiff's filing fee and to change the status of plaintiff's complaint from received on July 14, 2004 to filed on July 14, 2004. Oh, thank you. So ordered this 6th day of August 2004. Okay, Glendora says, received by Glendora on August the 11th, memo endorsed by Glendora on August the 16th. And Glendora says 28 U.S. Code Section 636 is very clear. No magistrate can touch Glendora's case without her consent in writing. This must be strictly construed. Both orders were superfluous. What this court needs is a clerk who can open mail and find the $150 money order in the envelope. Yours in truth and in Amor Patriae, Glendora. On the service list on it is, of course, to the Chief Judge and to the Clerk of the Court and to Orrin Hatch, Senate Judiciary, the House Judiciary, Mecum, the so-called Administrator of U.S. Courts, to George Bush, to the Center for Judicial Accountability, and to George McDermott, and to the Glendora TV audience and to the internet audience. And that's it. There's Opus 1183. It's too late now. It's 1189. I left that out. It took an hour and it cost $2. Wasn't that nice? Did you know about these two men who had a pact? The first one who died and went to heaven would come back and tell the other one if they had baseball in heaven. And Matt died first and he came back and he's, Pete, they got baseball in heaven. Pete says, hallelujah, praise the Lord. Matt said, but I got bad news too. And Pete says, oh no, do we have to have bad news too? Matt says, you're pitching Friday night. Folks, this is the 5th legal paper, the 6th, that came in last Wednesday. And this is from the County Court, County of Columbia, State of New York, United States of America. Received by Glendora on Wednesday, August 11th. Memo endorsed by Glendora today, August the 16th. And it's Preferred Country Properties. That's Natalia versus Glendora. And one word is enough. And it's a decision in order. And it's by J. Nichols. It could be Stanford Judge or Stanford Jonathan. And it says, by motion, dated June the 29th, 2004, actually it was by an application. Defendant, that's Glenny, moves for an order pursuant to CPLR, Civil Practice Law and Rules, Section 5519, staying the judgment of the Chatham Village Court, George Dixon, rendered on May 4th, 2004, in favor of the plaintiff, that's Natalia, Preferred Country Properties, for an aggregate damage in the amount of $1,995.19. A review of the motion and supporting documents that Glendora submitted reveals that the defendant, Glendora, has adequately demonstrated that her appeal is factually meritorious. Hooray! And Glendora says, thank you. And that she does not possess the financial means to submit an undertaking. And Glendora says, thank you. You know what they have in mind, don't they? Double the amount. Double the $1,900. Call it $2,000. They want an undertaking of $4,000 to stay the collection of the judgment. Phony judgment that it is, and crooked. Accordingly, this court hereby exercises its discretionary authority and grants a stay notwithstanding the absence of an undertaking, and Glendora says, thank you. However, this court's grant of a stay is conditioned upon Glendora settling the record on appeal within 20 days. That would be August 23rd. Yes. Filing her appellant's brief within 40 days, that would be May the 13th, of the date of the disposition order, in the event that defendant fails to comply with the aforementioned conditions, preferred country properties may move on notice to lift the stay. Footnote: defendant's original motion for a stay was denied by decision in order dated June 14, 2004, without prejudice to defendant resubmitting an application for a stay upon a proper evidentiary basis. So we passed the evidentiary basis. By the same motion, which was an application, defendant also moves for this court to recuse itself regarding defendant's pending appeal. Well, defendant's motion is denied. Glendora says, okay. Accordingly, it is hereby ordered that all proceedings on the part of the above-named preferred country properties, its attorneys, and the sheriff of Columbia County be, and they hereby are, stayed from taking any and all steps pursuant to the judgment of the Chatham Town Court dated May 4th, 2004, pending the hearing and determination of the appeal taken herein from said judgment by Glendora, and a whole lot of other names, and I cross those all out, appellant, on condition that said appellant perfect and submit the appeal within its time frame set forth this court herein. Glendora says, oh, first of all, when it said stay the judgment, then don't let the sheriff collect it, and don't let preferred country properties try to collect it, or its lawyers. Glendora said, thank you. And Glendora says to the rest of this, okay. This constitutes the decision and order of the court dated August the 3rd, 2004. I think this is an original because, no, it couldn't be. But it is smudged, so I thought it must be an original because I smudged it. Would you like to see his signature? Jonathan D. Nichols. Not bad for a man. And actually, it's not bad for a judge. And this is served on all entities named on Glendora's service list, Glendora, and see this on the internet and on a chat with Glendora. Hooray, hooray, hooray. Thank you, thank you, thank you, thank you. Well, the appellant's brief is the appellant's brief is already written because I use it as an attachment to my notice of appeal. So now we got to see if Dixon can do this one right. He certainly failed on the other appeal with Glendora versus Nasty Italia. See, there's two lawsuits, Glendora versus Nasty Italia and Preferred Country Properties versus Glendora. Beside us to guide us, our God with us joining, ordaining, maintaining his kingdom divine. So from the beginning the fight we were winning, the Lord was at our side, all glory be thine.
He's sweet. Oh, he's so sweet. He's so sensitive. Yeah, you gotta be good to him.
And here is Kleinbaum's appellee's brief on the other lawsuit, Glendora versus Nasty Natalia. And he has it all mixed up, of course. He's got it the wrong case here. He's got Preferred Country Properties versus Glendora instead of Glendora versus Nasty Natalia. So I will write the appellant's, that's Glendora's, reply brief to this. That's the next legal paper. And that's number 7 out of the 9 that came in. And number 8 will be the one I just told you about. I have to lead Dixon through all of the steps to make his return to the court on Preferred Country Properties versus Glendora. I bet he'll mess this one up too. So once more under the breach, dear friends, shout God for England, Harry and St. George. Glendora versus Nasty Natalia, Brat's sister Lydia, Mother Marie, Father Carlos, and Preferred Country Properties. This is the appellant's reply brief on pretty orange paper, an orange cardboard cover. Okay, it's being printed It's 16 sets and it's 60 pages. Now folks, you see this? This is called Meditate Create. What do you meditate about? What you're supposed to do. You find out what you're supposed to do. Then create is to go do it. But this had to be abandoned way back in March of 2003. That's a year and 3 or 4 months ago. And one week it looked as though I was going to have time to do something besides sue bad judges. And so I looked at it and said, well, maybe I can make it up. Make up a year and 3 months? Well, I tried, and guess what? Today I made it. Here it is, August, and I made it. It's up to date. Here is June and May 2004, and all the way back here. All the way back. December 2003, I made that up. Isn't that something? See, it's only a couple of blocks that you fill in every day, that's all it is. But it's great stuff. Oh, it's great stuff. And do you know what it is I'm supposed to create? So this brave little machine printed 16 sets, 52 pages. And they've all been collated. And 2 of them have been stapled, labeled, and stuffed. And we'll be reading it to you very... Now, let's see. You turn on the camcorder first, and then you turn on the VCR to record. Instead, I turned off the power. Okay, VCR, record. Okay, there's the sign. At standard play, record. This is something new, folks. I don't have time to make a videotape of this on 8mm and then go back over and do the whole thing and make a VHS of it for Chatham TV. So this is the first time I'm trying to videotape and edit simultaneously. I think it's working. Who is this? Judith K. And I do mean Judith K. Big packet, Judith K. Jan H. Primadora, Deputy Administrative Judge, New York State Courts. And the big guy, the Chief Judge. No, I shouldn't say that. The Chief Administrator of New York State Courts. He handles the ones in New York City. Primadora does the ones outside of New York City. You remember, that's old Trafficante's job. Clerk of the Court, Chatham Village Court. You're looking at 54 pages in each one of these envelopes. Preferred country properties. Nasty Natalia, Brat Sister Lydia, Mother Marie, Father Carlos, and preferred country properties. The village of Chatham, that would be George Dixon, the so-called justice there, and his wife, the clerk, Joanne Dixon. James Kleinbaum, Natalia's lawyer. Now, you pronounce this one for me, please. Tembechian? That's kind of pretty. New York State Commission on Judicial Conduct. Complaint about George C. Dixon. Jonathan D. Nichols. He's the appeals judge in the county court for this paper. Administrative judge for the 3rd district, I think, or the 3rd department, or whatever. New York State. Ceresia. And the clerk of the court, County of Columbia, in Hudson, New York. Now, folks, here it is. 19 hours of work. But it's amazing that this got done. It was started at 3 p.m. Monday. It was finished written at, it started at 4 p.m. Monday and finished written at 3 p.m. Tuesday. And it was 9 hours just to write it. And then that poor little copy machine over there did 16 sets, 52 pages each. And then it had to be collated, and then all those envelopes had to be made, and then stapled. That's a nice staple, very big, expensive stapler, $25, but it's good. And this is his little brother who does the little work. Labeled. Each person's name has to go on this. My name's on this one. And stuffed. And it hasn't been sealed yet. You wait until the last minute to seal it, because you usually forget something, right? You usually forget something. Like I've forgotten to tell you jokes. I've got to do that. I'll tell you one joke to get us off to a good start. Joy and jokes. Joy, jokes, and justice. Joy, jokes, and justice. These two fellas had a pact. And the first one who died and went to heaven would come back and tell the other one that there's baseball in heaven. So Matt died first. He came back. And he said, Pete, they have baseball in heaven. And Pete says, praise the Lord, hallelujah, baseball in heaven. Matt says, but I got bad news, too. And Pete says, oh no, do we have to have bad news? And Matt said, you're pitching Friday night. This is the Supreme Court, County of Columbia, State of New York, United States of America. We have to say all of that because this is going worldwide on the internet. And to be argued by Glendora. The index number in the lowest court is 04. That's for the year 2004. 03. That's for the month of March. And the number is 129. Chatham Village Court, George C. Dixon. This is Glendora Plaintiff Appellant versus Nasty Natalia, Brat Sister Lydia, Mother Marie, Father, Brother Carlos, and Preferred Country Properties, a real estate agency in Chatham, which you must eschew. And this is the Plaintiff Appellant Reply Brief. And there's Glendora's address, and there's Natalia's address, and Kleinbaum's address. I have to stop. Remember, joy. Every 15 minutes. And what are we going to rejoice about? This is good. This is really good. Listen to this. I hope I can get the tune on this. Beside us to guide us, our God with us joining, ordaining, maintaining his kingdom divine. So from the beginning the fight we are winning. The Lord was at our side, all glory be thine. Okay, that's our joy. Let us log it in here at 8:30 a.m. read you this. This is an exclusive, you know. This is an exclusive on Charter Communications Television on Channel 7 on Fridays, A Chat with Glendora, every week at 9 p.m. James Kleinbaum, would you like to know his address? I don't know it either. 18 Park Row, Chatham, New York. And it says, to Glendora Westerfolsen Bureau, which is nonsense, it just should say to Glendora, Box 124, Ghent, New York. And it says, regarding preferred country properties versus Glendora. He's got the wrong lawsuit. There's two lawsuits. Okay, preferred versus Glendora and Glendora versus Natalia. And they put a hyphen between Folsom and Buell. And they have the wrong case. Please find service upon you the respondent's brief with regard to the above-mentioned matter. And here's his signature, and the signature tells you what about him. Mind is all mixed up. Cannot take time to write an orderly signature. I pray for you, James Kleinbaum. I want you to be whole, happy, and healthy. This is no way for you to live. Okay, and this is the State of New York County Court, Columbia County. That's a funny way to put it, but they do things funny up here. And this is Glendora appellant against Nasty Natalia et al. And it's a respondent's brief. Chatham Village Court, index number 0403129. And Glendora tells Kleinbaum that your first paper out in the court has to list all parties. Okay, that's lazy. Okay, there's 5 parties, and you missed 4 of them. And it says Kleinbaum, preliminary statement. This appeal is taken from the judgment of the Village of Chatham Court. How about this paper is taken from? Oh, that's okay. From the judgment of the Village of Chatham Court. Village Court of Chatham, I think is what I was looking for. It should be the Village Court of Chatham. Dismissing the appellant's small claim at a hearing before that court on April the 13th, 2004. And Glendora says, and never put in writing. Do you know that Dixon never put that in writing? Dixon had no something to rule on, and Glendora's motion to put the decision in writing. Oh, Dixon had 60 days to rule on Glendora's motion to put the decision in writing. Dixon failed. The decision is automatically a nullity pursuant title to CPLR 2219. Says Kleinbaum, statement of facts. The respondents filed eviction proceedings for non-payment of rent, which was a lie. The rent was paid. What wasn't paid is Natalia's bills. Glendora paid for repair of the furnace at $183, repair of the kitchen sink for $26, and Glendora, an apartment dweller, should never have to pay water. Appellant in the Village of Chatham Court, and well, I'm going to say it right, in the Village Court of Chatham, or in the Chatham Village Court, on March the 18th, 2004, the hearing date for the summary proceeding was set for March the 23rd, 2004 at 6:45 p.m. But these people tried to give it to me, but they didn't give it to the court. Now, does that make sense? You issue a summons on somebody and you don't give a court a copy? And so Glendora says that this is a lie, and the service was properly and personally effected upon the appellant. This is a big, big, big lie. There was no in-personam service. There was no regular mail service. There was no nail and mail. It's supposed to be affixed to the dwelling, and then mailed regular mail and mailed certified mail. despite her attempt to evade service. This is lie number 8. This issue was duly addressed. This is lie number 9. It was not at the proceeding in the court below. It was not duly addressed. And Glendora says, you prove it, Mr. Kleinbaum. This is all conclusory. 9. Glendora demands a Travis hearing. If you say that Glendora was duly served, then you prove it in a Travis hearing. Now, another thing that was wrong is that they had a cop serve it. They had a cop, a Chatham cop, serve it. And cops are not supposed to do process serving. And Glendora's audio tapes prove that Kleinbaum is lying. And now we're up to his lie number 3. And Kleinbaum says on March the 23rd, 2004, the case was adjourned to by consent, on consent. Okay, this is lie number 3. Glendora did not give her consent to adjourn the case, because the March 23rd, 2004 date was a criminal part date for the Village of Chatham Court. Chatham for Chatham, Village Court. And the next time he makes that ambage, I am just going to read it correctly. And Glendora says, prove the consent. Glendora did not consent. Now that's page 5. Let's do page 6. And I'm getting a signal from my sweet camcorder that he wants something. I don't think he wants a new tape, but I think he wants battery power. Why don't I just get up and plug in the battery? And then he will stop flashing. Well, that should give me time to tell you another joke. What happens when ducks fly upside down? What happens when ducks fly upside down? They quack up. They're sort of like judges. There, let's see if it stopped flashing. Yes, it stopped flashing. I'm going to reach up to page 10, and we're going to take a break. This is 50 pages long. It says Kleinbaum. On the March 23, 2004, the appellant filed a small claims case against the respondents, claiming $3,000 in damages for, quote, personal, unquote. The court adjourned the hearing date for the summary proceeding, as well as the small claims case, until April 13th, 2004. That's wrong. When I filed my case against Glendora versus Nasty Natalia et al., it was not an adjournment until April the 13th. It was the assigning of the proper date, because when you file an action against somebody in small claims, you have to give them something like 3 weeks. This was March the 23rd, and Kleinbaum says that my Glendora versus Natalia was adjourned to April 13th. It was not, okay? You can't expect a person to answer a lawsuit in a week. Oh, although Natalia tried to pull that on me. And they call it a summary proceeding. But it was the worst paper. You remember I read it to you? It was such a piece of slop. It never even said at the top, SP, for summary proceeding. And it never had a case number. Glendora versus Nasty Natalia et al. Was never adjourned. When the complaint was filed, the court date was set for April the 13th, because it is a law. Defendant has to be given 3 weeks to respond. Kleinbaum has already struck out 3 lies. Kleinbaum does not paginate. No. Can you imagine that? Being that dumb? Not to paginate a paper. And he does not enumerate his paragraphs. Kleinbaum's unpaginated page 2 we are now addressing. And it is lie number 4. How could the court have adjourned the Glendora versus Natalia at the hearing of Preferred versus Glendora when Glendora versus Natalia had not even been filed yet? It was filed after the hearing, and Glendora's audio tape is the proof. Also in dispute is calling the March the 29th court appearance a hearing. Glendora was not heard. Kleinbaum's paper of March the 18th was fatally defective, as the court's scrutiny of Glendora's complaint shows you. Glendora versus Nasty Natalia, that complaint was for 100 pages long. And it amply delineates all of the defects in Kleinbaum Natalia so-called summary proceeding to vacate in 3 days. Now that's just plain nastiness, and that's why the lawsuit is called Glendora versus Nasty Natalia, along with a few other nasties. For instance, it had no case number, nor was it marked SP for summary proceeding. Also note that Kleinbaum has been calling it a summary proceeding. It was not a damage proceeding. Why is that important? Well, Kleinbaum Natalia never filed a damages complaint. They and Dixon were wrong not to drop the summary proceeding instantly after Glendora vacated March the 28th. This summary proceeding, the cop appeared at the door with it on March the 18th, the day after St. Patrick's Day. By March the 22nd, Glendora didn't want anything more to do with Natalia and that property in Chatham, which you know so very well because you saw it on videotape so much. She didn't want anything more to do with such bad people, except of course to pray for them. She wanted out. So on March the 20th, Friday, she went and bought all the newspapers of the area that were available, cut out all of the ads for rentals and pasted them up. And by Sunday night, March the 22nd, Glendora had found one that she thought sounded pretty good. On March the 23rd, Friday, at 5 p.m., she looked at it and took it and made a deposit. And then a couple of days later sent a money order to the owner for the security and for the first month's rent, April. And vacated, and then got everything moved with the help of her wonderful neighbors by March the 28th, Sunday. Is that right? Yeah, that's right. March the 29th was Monday, and March the 30th was the date of this so-called second hearing. Kleinbaum says, by the adjournment date, the appellant had already vacated the premises. Now that should have stopped everything right there. At the adjourned hearing, the only issue was the respondent's damages and the appellant's small claim. That ended the case right there. The summary proceeding was over. Because in the summary proceeding, it did not list damages. It was not a complaint for damages. No complaint was ever filed for damages. And so therefore, these damages had no standing. There was never a complaint filed dealing with damages and asking for damages and pleading for damages. So this is line number 5. Respondent's damages never existed as a lawsuit. It had no standing. Line number 6. Glendora's small claim, Glendora versus Nasty Natalia, was not adjourned. It had not even come up. It was set on March the 23rd for court on April the 13th. Line number 7, Kleinbaum says, appellant and the respondents, through their attorney, appeared on said adjournment date. After a hearing on the respondent's eviction proceeding, the court granted the respondent's damages and rental arrears, subtracting the security deposit from the amount awarded. Whoa, wait a second. First of all, you understand there was no more a summary proceeding because Glendora vacated. But dumb Dixon doesn't know that. And dumb Kleinbaum leads Dixon around by the nose. Then there was Glendora's April 13th hearing. Was not an adjournment, as I've explained to you. It was a set court date, the first date of court. And then what else is wrong here? The court granted respondents damages. Never should have done that. The damages had no standing. A lawsuit had never been filed for damages. And rental arrears. There were no arrears in the rent. The rent was paid. When Glendora paid $183 for the furnace to be fixed and subtracted it from the rent, that's not an arrear. What is an arrear is that Natalia didn't pay Glendora the $183 for fixing her furnace, nor the $26 for fixing her sink drain. And now this is news. Subtracting the security deposit from the amount awarded. That's news to you, isn't it? Well, it's news to me. I never making progress here. We are on page 10. Do not allege sufficient facts to support her claims. Glendora says, this is a lie, number 11, or is it 12? Or what is it? Glendora presented the proof in the defendant's own hand. In other words, all of the papers that these defendants sent to me, where they lied and cheated, I reproduced and put behind their complaint. And that was the proof, in their own hand, that they had violated the laws. Judges had violated the laws. Things are upside down here. Besides, Rule 8 says that it should be a notice complaint. Besides, the court has a duty to accept the plaintiff's claims as true until proven otherwise. Now, every sentence, every phrase of Hebekins is a lie. Glendora has never known U.S. attorneys to do anything but lie. The worst liars I ever met are U.S. attorneys. They are schooled in 1,000 ones. Certainly the allegations do not constitute the short and plain statement of the claim required by Rule 8, Federal Rules of Civil Procedures, and the complaint should therefore be dismissed. Now, that is not grounds for dismissal. That would be grounds for an amended complaint, but it's not grounds for dismissal. This is how dirty U.S. attorneys are. And Johnson, his ghostwriter, really doesn't know what she's talking about. And she says the deficiencies of the allegations in plaintiff's complaint make it subject to dismissal under Federal Rules of Civil Procedure 12b-6 for failure to state a claim upon which relief may be granted. Glendora says, so you have said. And this is a lie. This is unsubstantiated. This is pueril. And it is a bunch of computer spit-outs that any third grader could punch buttons to eviscerate. Next slide. In fact, the complaint may be dismissed pursuant to Federal Rules of Civil Procedure 12b-1, whereas here the allegations of the complaint are so insubstantial, and yet I presented the actual lies of these people in their papers to me. Isn't it terrible? Wouldn't you hate to earn a living this way? Now this is lie number 13, and what is insubstantial is this slop by Johnson. It is all so valueless. The paper by Hebecan is bogus. Why is it bogus, folks? Because he's a U.S. attorney in Nebraska and he's defending people who are not in Nebraska. Plaintiff's claims should be dismissed for lack of subject matter jurisdiction. How can you say that? They're federal questions, aren't they? Constitution of the United States, U.S. Code, and the Federal Rules of Civil Procedure. Glendora is making it clear that federal jurisdiction is federal question and diversity of citizenship. You only have to have one. Take either one you want. These people are all over the United States, so that's diversity of citizenship. Glendora is not suing the United States of America, and don't tell Glendora who she is suing. You state no law. Did Congress make such a law? No. These spit-outs are just more bad decisions by more bad judges, and they're bad law clerks. These people think that all they have to do is quote decisions by judges. Well, you've got to know, judges, if you don't make the law in the United States, you are not a legislator. Only one part of the government makes the laws, and that's Congress. Judges do not make law. So you can spit out all of the bad decisions by bad judges you want. They are not law. So Glendora says your premise fails and your argument falls. Glendora has already shown the internet that Hebecan, H-E-A-V-I-C-A-N, is without a law. A suit for damages against federal employees in their official capacity is barred by the doctrine of sovereign immunity. Well, Glendora says, where is your law? When did Congress ever make such a law? Judges do not have immunity. Congress made no such law. Hard as they tried after the Civil War with the Civil Rights Act to get immunity, they failed. Judges do not have immunity. You can sue as many judges as you want. It is your allodium to sue as many judges as you want. Judges are not immune. This is so boring to have to refute infra digs, but it is good for Glendora to read on her TV show on the internet to show the world how bad judges, bad U.S. attorneys at all, have kidnapped our government. The government we love, folks, has been kidnapped. How are we going to rescue it? And you people steal our tax money to get paid for lying. You are a liar for hire. Furthermore, says Hebecan and Ghostwriter Johnson, the statutes cited by plaintiff in her complaint cannot serve as a valid basis for subject matter jurisdiction over plaintiff's claims against the federal defendants in either their official or personal capacity. And Glendora says rhetoric, prejudged, premeditated, and rationalizations. 59. Rule 42 U.S. Code, Section 1983, that's civil rights, creates a possible cause of action only where the defendant acted pursuant to state law. I think the U.S. Constitution is state law. I think the U.S. Code is state law. And I kind of think the Federal Rules of Civil Procedures are state law. Well, anyway, Glendora did. Again, World Wide Web, they have computer spitouts, but they have no law. The minimum you can expect, World Wide Web, of a U.S. attorney is that they know the law. That's the minimum you can expect of a U.S. attorney. It's easy to know law. What is it but sitting down with a cup of coffee or Sanka and reading it? Why do they call it Sanka? It has no active ingredient in the bean. This does not apply here. And all this ambush is adiaphorous anyway, because a Nebraska U.S. attorney has no jurisdiction to defend people in non-Nebraska states. We're up to page 14. This is just more spitouts. You know, folks, as acerbating as this frivolity is, it is still an honor and a privilege to stand up for the United States of America against these dissolutes. Glendora won power, or then now they get into private right of action. You know what private right of action? That I as a citizen have no right to bring an action against a judge. I have to go through the U.S. attorney. Well, I won on private right of action a long time ago, in 1995, in the United States Court of Appeals for the Second Circuit. I have a private right of action. See what they would turn this country into, these wretched U.S. attorneys? And for all these reasons, plaintiff's complaints should be dismissed for lack of subject matter jurisdiction. So you have said. Habby Cam and ghostwriter Johnson, and Johnson's ghostwriter, she has a ghostwriter too, fail to prove their case, but what difference does it make? They have no statutory authority to defend non-Nebraska defendants. Plaintiff's complaint against the federal defendants must also be dismissed for lack of personal jurisdiction pursuant to Federal Rule of Civil Procedure 12b-2. So you have said 3 times. This is bulk, and no weight. The whole thing was 7 pages, and it took me 32 pages to refute their lies. Alas, poor York, we go from legally illiterate to grammatically illiterate. She says, and none of the acts upon which plaintiff's claims are based recurred in Nebraska. Now the internet beats suing. And you are wrong the 20th time. This is a civil rights case, and a civil rights case can be brought in any federal court. They say that I don't have venue because all these events did not happen in Nebraska. But this is civil rights. A civil rights case can be brought in any federal court in the United States of America. Now, again, World Wide Web and cable TV viewers, we have spitouts. And down here we say nothing irks a pro se more than an amateur lawyer. Nothing irks a pro se litigant more than an amateur lawyer. Now this is all adiaphorous because this paper is a nullity. This paper by Heavy Can is a nullity, and this has taken 4 hours to write so far, up to there. Now, in addition to the defects noted above, the plaintiff's claims against the federal defendants must be dismissed pursuant to Federal Rules of Civil Procedure 12b6 for failure to state a claim upon which relief may be granted. How many times? It's a broken record. Glendora says this is addled, empty, rotten, confused. Since when is violation of the U.S. Constitution not a claim upon which relief can be granted? Since when is violation of the Federal Rules of Civil Procedure not a claim upon which relief can be granted? Since when is violation of the United States Code not a claim upon which relief can be granted? Even bare, non-amphibolous 28 U.S. Code 636, which says a magistrate has to have the written consent, even that is eschewed in this alphosis by Havacan ghostwriters. It is not Glendora's burden that Johnson does not have the acumen to understand. Conclusory is overworked. Nothing was conclusory. Glendora adduced the proof of the papers by the violators in their own hand. Again, the papers that these dopey judges sent Glendora, and wherein they violated the three things, the Constitution, the Code, and the procedure rules, which was in their own hand. There was the proof. Isn't it awful how they just lie in broad daylight? By hook or by crook. By hook or by crook. So this is 1001 cheating by Havacan and by Johnson. What do you think of the depravity in the United States courts? Does it make you cry? Does it make you jump up and down? What do you think of it, World Wide Web? Now, I don't think there's any point in reading any more of this. It is all repetitive, and it is all wrong. It is all a denial of Glendora's due process. And so Glendora, as it says, goes through the alimentary canal of another United States District Court. Isn't it sad, people all over the world? Glendora does not allege U.S. courts are totally depraved. She adduces the same with 10,000 pages of slop, such as what you read here, seen and heard herein. As noted above, none of the statutes cited by plaintiff creates a cause of action for damages against any federal defendant. Well, I do not recall her producing any proof of the same, do you? There is no way the All-American complaint, perfectly pleaded, can be dismissed. That is, that there is dismissal legally, honestly, honorably, by someone who took an oath to uphold the Constitution, who pledged allegiance to the flag of the United States of America. No such person can dismiss this complaint. But that's not the kind of a person that we have in a black robe in U.S. district courts. To adduce is to bring forward, Glendora says, as proof what has been alleged. Glendora did that in her complaint, the papers by their own hand. Havacan and Johnson, what do they know about Title 28 U.S. Code, Section 1441 et sequitur, venue? When they don't even have venue to defend defendants that aren't in Nebraska and who do not do business in Nebraska. Furthermore, to the extent that plaintiff has alleged any facts, it is clear that the claims against all federal defendants are based on judgments and orders issued in federal court cases, which violated the United States Constitution, the U.S. Code, and the Federal Rules of Civil Procedure, and violated Americanism, belief in and adherence to the USA, its ideals, interests, and traditions. Now, Heavy Can, thinking he can get away with defending non-Nebraska defendants, equals Richard Stearns, think that he can get away with dismissing Glendora's case, and Stearns is a Boston judge, and the case was filed in Chicago, and Stearns thought he could get away with dismissing Glendora's case when he's a Boston judge and has jurisdiction only in Boston, thinks he can get away with dismissing a case in Chicago. No wonder your tongue and your teeth get all mixed up trying to follow and expose the things these judges do. No wonder. Now don't laugh, Internet. It's not, I suppose it is funny that a dumb judge in Boston thinks that he can dismiss a case in Chicago. I suppose it is laughable. But it's a sick nadir. It is well established that judges are immune from suits for damages arising out of their. Glendora says, oh really? Would you mind quoting the Congress law on that? Would you mind producing the proof from the Civil Rights Act, Title 42? Let me tell you folks, nobody is immune from Section 1983. Title 42, Section 1983. Nobody is immune. Civil rights. We're up to page 22. No, we're not. We're up to page 24. That's good news. She makes an important point, she thinks, and she puts it in a footnote. Now, can you tell me why a U.S. attorney cannot write an integrated paper? There's no need for footnotes. You can write a paper that is integrated. But then, that takes integrity. That takes integrity. Now, she says this is true, that you can't sue a judge, even if the judicial acts were allegedly wrongful or even unconstitutional. Now she's admitting it. Thank you for that. And I'd like to know who says that you can't sue a judge. But you are thanked for admitting wrongful and unconstitutional. So away she goes, saying that judges cannot be sued, and Glendora says, are you a legislator? Are you an elected congressman? Produce a law by Congress that states this. You will need it for your defense. And now, will you be appearing pro se? Now look at her signature. I can't read it, can you? I can't even see it, can you? Can you see the signature there? Right down there. Can you read that signature? What's that tell you about her mind? And she says, respectfully submitted. And Glendora says, it is not respectfully submitted when it's full of Section 1001 misrepresentations. And Glendora poses a question. Were the judges and clerks and other state actors Glendora sued right or wrong to lie, steal, and cheat, and betray their country? Would you answer that question? I think that's the gravamen of the lawsuit. For the reasons stated above, plaintiff's complaint should be dismissed with prejudice. Glendora says we can be certain there will be prejudice and bias. And ignoring of Title 28 U.S. Code, Section 141 and Section 354, which says that a judge must recuse if he is prejudiced or biased. Peroration. Says Glendora, it is the allodium of Glendora to sue any judge. It is your allodium to sue any judge. That means you hold that right independently, without service, without payment, without being bossed around by anybody else. That is your allodium. Sue judges. And here's the certificate of service that it was served electronically, and it was served in Glendora. But want to note something here, folks? Why did she have two certificates of service? Why two certificates of service? Okay, the big point here is that Heather and Johnson did not serve all parties. They served Glendora, and that's it. They did not serve all of the defendants. It is not biased and prejudiced with self-interest and agglomeration of judges. You know what agglomerate means? Into a ball. That's what judges do. They roll themselves into a ball. They all stick together. Glendora has not found in the U.S. District Courts and the U.S. Court of Appeals across the country, Bangor to Los Angeles, a fair forum. Besides, Glendora is running out of U.S. District Courts to sue in. You look at this, and you call out a state, and I'll say, yes, I filed a lawsuit there. Call out another state. Yes, I have filed a lawsuit there. Yes, I have filed a lawsuit there. Call out a state, folks. Texas. Yes, I have filed a lawsuit there. Nevada. Yes. Salt Lake City. Yes. Little Rock, Arkansas. Yes. So, Glendora is running out of courts to sue in. What's our joy? Remember? We rejoice over something every 15 minutes. I rejoice over the sunshine, very little, which we've had this summer and this spring. Rejoice. Rejoice, give thanks, and sing. There is no return date on the bogus motion, no notice of motion. It is a repetitive laundry list. Glendora's demand for jury trial, Rule 38, Federal Rules of Civil Procedure, is ignored. And what can you expect of these people? Due process is promiscuously denied. Allegiance to the USA is aborted, abased, and abashed. Glendora charges obstruction of justice. Now that's no joke. This is obstruction of justice, what they've done. And it's also mail fraud. Obstruction of justice is Title 18 of the Criminal Code, 1503. Glendora charges mail fraud, and would you rather be sued or would you rather go on the internet? How about both? Again, suing judges is Glendora's allodium. And under penalty of perjury, Glendora avers that she has told the truth, the whole truth, and nothing but the truth, so help her God, and that you have not. This notice of cross motion and affirmation in support was served on Heathercan and Johnson at their designated address on August 19, 2004, Anno Domini, and service was by U.S. First Class Mail prepaid. Conclusion. Glendora must be awarded all of the relief sought in the wherefore of her complaint, together with the cost of this cross motion and any other relief just and proper. Dated August the 19th, 2004, State of New York. That should be the 19th, that's wrong. Yours in truth and in amor patriae, Glendora. A chat with Glendora on 45 TV stations equal 450 municipalities. Glendora service list, August the 18th. Heavy Cam Johnson, Clerk of the Court, Glendora TV audience, Glendora Internet audience, the Center for Judicial Accountability Incorporated, George McDermott, the U.S. Attorney, Nebraska, thinks he has jurisdiction over 25 non-Nebraska defendants. This is Opus 1192. It's 11 and a quarter hours. It's $13.60, and it goes to Congress, and it says, how about this, Congress? Here's a U.S. attorney in Nebraska who thinks he has jurisdiction over 25 defendants outside Nebraska, Glendora. And the estimated program number on the internet is 3,856, edition 9, and the estimated debut on the internet is the first week of September. Of your debut. And there's Bob Hope, who lived to be 100. Let me make a couple corrections. And you should be told some jokes. Let me see if I can find you some jokes. Edith was asked, why do you always take your paycheck to the bank? And she said, it's too little to go by itself. And Marilyn says that she was depressed and miserable, but in the past year she has turned that all around. Now she's miserable and depressed. Joe wanted to go to Paranoids Anonymous, but they wouldn't tell him where the meetings are. And why does Marilyn call her son-in-law Blister? Because he never shows up until after the work is done. Pete is walking along the beach, and he picks up a seashell and he puts it to his ear, and a voice says, why aren't you working, you bum? It was his mother-in-law. And what's the difference between a Xerox machine and the flu? A Xerox machine makes facsimiles, and the flu makes what? Sick families. And Robert puts us in an interesting way that he went on a half-a-year cruise. His friend tells, yeah, he went up the river for 6 months. Bob was very happy that he sold the house he lived in for $450,000, but the landlord was upset. This is the cutest thing. This little boy and his dog always went to school together. They went off to school every morning together, and everybody thought it was so sweet, and they would come home in the afternoon together. But finally they got separated. The dog graduated. We have here, on a chat with Glendora, the Riverhead edition, Zabby reports on the sellout to greedy Cablevision by Southampton politicos. Vultures violate the statutes. Vultures try to rob us of our rights to public access TV. Protest 631-283-6055. We'll remember.
Go. Turns on at 9, stops at 11, and rewinds at 11:01.
Oh, it's so smart. I love it. I just love it. Now I gotta make up my mind whether this is an hour. This is 2 hours, and this I know to be 2 hours.
Both of those?
Yes. You want my pen to mark it?
Yeah, that's one of my desk.
You want to keep that pen?
No,
a nice
it's all right.
pen, and it's not for me. Okay, they're both there. Okay.
So we won't even have to change the program now. So the
What's
next
that
two
mean?
are 2 hours.
Oh,
So
I
it's
see.
length, so.
Oh, okay. That's good, isn't it?
Yeah. You watch yourself.
That is very good, isn't it? Well, thank you very much.
No problem.
I see you next week, but not the week after. Is that right? Or I don't see you next week. Which
No.
is it? Which is it?
You gotta see me before the 10th.
Yeah, but do I see you next week?
Well, it's up to you when you have the date clean up, but anytime before the 10th.
Okay, you will be here this week. Next
I'll
week.
be here next week,
The last week of August.
and then the last week of August, the beginning of September, I'm gone. Then I'm back the following week.
And what's your exit date? August 27th? Is that your exit date, August 27th?
Yeah.
That's a Friday, a week from this Friday?
Yep.
Oh, great. Well, I want you to understand how appreciative I am
Okay.
and how much I enjoy the whole thing. I just love being around this stuff. Thank you.
Okay.
Oh, I didn't tell you a joke, did I?
Not yet.
I told you about the freighter with the red and the purple paint.
Yes.
Okay, well, this freighter was carrying a load of yo-yos, and it hit a reef off the coast of Nantucket and sank 5 times. I love them. I love them. I love them. I love them. Will the internet ever replace cable TV? No, I don't think so, because Brooklyn, well, maybe so. Brooklyn, public access, streams all of their programming from 9 o'clock in the morning to 1 o'clock in the morning, all day long, up onto the internet, each day. So there you are, Charles Dolan. You don't have to have cable TV to get public access in Brooklyn. Ha ha! Every day? Yeah, most every morning. Will you talk to my plants every day? Talk to them. Oh, that I'll do. One woman says, oh, and the husband says, well, I never heard them answer. And the woman says, well, that's because they're mums. That's good. And then what did she say? She says, I have one plant I won't. I think they're doing pretty well now. See, the air conditioning is bad. They're tropical plants. And they've lost over 100 leaves. Look at this. That's too bad. Because that's her growing arm. This is Mother. I rescued in 1997. And now when she was moved, she lost the top right here, see? But now she's making up for that. And the philodendron is so happy. And this is her son, Franklin too, who hit the ceiling. And now he has to turn around and come down. I never knew the name of this plant. I never knew what species it is. I never knew what it's supposed to do. But I couldn't see. Some neighbors moved out and they just tossed this poor plant into the field to die. So I went out and rescued it. Frankie and I did. Think how long ago that is. 16 years. This is my favorite plant here. This little fir tree. Isn't that adorable? And that's growing at least a couple of feet since I'm not 90% of this away. But there's all these that you have to go to the window for. And a whole lot of it went into there. 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. That's cute.
Hello.
Hello. Yes, please. 6 donuts. Okay, what kind of pie is a little one? Ginger, pear, and apple. Okay, could I have that, please? Ah!
I'm sorry about that.
Ah!
Half a dozen, right?
Yes, please. Are they all the same?
Yes.
They're all cinnamon, right?
Mm-hmm. Yeah.
Is that an ominous guy? Just as soon as I turned the camera off, there was a streak of lightning right in front of you. There's another one. I've seen about 5. Here's the one-lane bridge. This is a vegetarian real meal. Vegetarian hamburger, mashed potato, peas, and gravy. Let me find the hamburger for you. Well, mine is all eaten. And after 50 years of being married to Franklin, I cannot prepare a meal unless I prepare a second one along with it. So we'll give this one to the skunks tonight. They love it. And it's good for them to have a good meal. And what do you eat with it? A millet muffin and a glass of ice cold grape juice. And after that, you have to wait a while for dessert, because this is mighty filling and mighty satisfying. We gather together to ask the Lord's blessing. He hastens and chastens his will to make known. The wicked oppressing now cease from distressing. Sing praises to his name, he forgets not his own. So what is it? A vegetarian meal? Vegetarian hamburger and gravy and mashed potato and peas and a millet muffin and a glass of grape juice. Marilyn was asked, "Why do you always take your check to the bank?" And she said, "It's too little to go by itself." Up on yesterday's morning work that had to be put aside because of the Dolan Zabby bulletin, and had to be put aside because of going to Chatham TV and handing in the program and going to the Ghent post office and going to the laundry and doing grocery shopping at 5 stores and going to Walmart to get these new pillows. You had to get them. They're red, white, and blue. Now these pillows were about $10, or close to $9. And 2 weeks ago they were marked down to $5, and this week they were marked down to $3. So, there's one for each chair. So where were we? Yeah, Walmart. And of course, it was hot and muggy yesterday. There wasn't any really strong sun, you know, a nice summer day, not at all. And over at the museum last night, it started to lightning, and it started to thunder, and it started to rain. Then it stopped. I unloaded the car. It was 15 loads and 15 bags of put away. And this morning at 5 a.m., I opened the door, and here it is, pouring rain. Pouring rain. So this is Natalia, and this is Appellant Glendora's brief in Preferred Country Properties versus Glendora. They don't pay for the furnace bill that I paid for, and then they sue me. How's that? And I'm writing a docket for it. And this appellant's brief is going to have a very interesting twist. And when it's over and done, I'll read it to you.
Look at this, folks. Look at this. A blue sky. A blue sky. Can you believe it? And no clouds. Well, you know. But look at it. It's azure blue. This is the first day in 10 days, right? First day of summer press. It got here before summer was over. I have to wrap 45 videotapes. Will you help me, please? Will you please help me? I can assign them, and you can put Box 124, Ghent, New York, and media mail, and a 60-cent stamp and an 83-cent stamp. Okay? And then most of the addresses are printed. You just cut out and paste. Will you do that for me? Oh, church was wonderful this morning. And then we had punch out on the lawn. On the sidewalk. There go your jokes. What's the difference between a Xerox machine and the flu? The Xerox machine makes facsimiles. The flu makes sick families. And Marilyn was asked, why do you always take your paycheck to the bank? Marilyn said, because it's too little to go by itself. A man was walking along the beach, he picked up a seashell and he put it up to his ear, and a voice says, why aren't you working, you bum? It was his mother-in-law. Bill says he took a half-year cruise, and his friend set people straight about that. He was sent to the river for 6 months. Let's see. I know that my advice is very good because people never come back for more. And Bob is happy that he sold the house he lives in for $415,000, but his landlord's kind of upset. Diane says that she's been depressed and miserable, but she turned that all around in the last year. Now she's miserable and depressed. Ed wanted to go to Paranoids Anonymous, but they wouldn't tell him where they held the meetings. And why does Bob call his son-in-law Blister? Why does Bob call his son-in-law Blister? He never shows up till after the work is done. And this is the cutest thing. This boy and his dog went to school together. They leave in the morning, and then they'd come back in the night. And they were always together, and everybody thought it was so cute. And then one day the whole thing broke up. The dog graduated. Take care, folks. I'll go in and wrap those 45 videotapes. looking at this the wrong way. I should be saying we enjoy every minute of it. We actually got 3 done before going to church. And here's the rest of them over here to be done. And here's the distribution of them. Certain editions go to certain municipalities because they are about news in that municipality. So, cheerfully and happily and with great joy and thanks, we will wrap 45 videotapes. Here's a bunch of videotapes that George McDermott sent me. These are Super VHS. And what's the matter with you, Circuit City? You used to charge $5 for these. And now you're charging about $12. You're worse than Radio Shack. Pray and praise without ceasing, glory in the perfect love. Rejoice, another blue sky. 2 days of blue sky. This is Riverhead, a special edition. Zabby's report on the Politico meeting, Southampton. Do not sign the Cablevision contract. Do not. And now it's put away. 41 videotapes have been wrapped. This is one box, and the other box has been loaded into the 1993 Lincoln. It was 41 tapes, and we did a lot of piggybacking. We had them left over, so we doubled up and sent one for each week to a lot of the systems. Albany, for instance, got one for August 30th and then September 6th, Labor Day, and so forth. Quite a few of them got 2. See that precious blue sky? It's about the 2nd day of summer we've had. Well, maybe a few more. See, these are the addresses. Like that one's Manhattan Cable TV. Great Neck. Rye, so forth. Greenberg. Oh, Cox. You gotta do something about Cox. Get the program on in Manchester, England. Who is this? Oh, that's Heidi in Time Warner, Poughkeepsie. Okay. Put away the wrap. Hooray, hooray, hooray. And Marilyn was asked, why you always take your paycheck to the bank? And she said, it's too little to go by itself. Here's the Towns Where Chat with Glendora is on. Continental's Peekskill and Ossining. East Hampton, Riverhead, Great Neck, Nassau, Harrison, White Plains, Los Angeles, Santa Fe, West Seneca, Harrison again. And I read that wrong, it's Hopog. Portland, Oregon, Norwalk, Connecticut, Cross River, Brooklyn, Bronx, Staten, Queens, Manhattan, Mount Vernon, and Rye. It's not on in Yonkers right now. Cablevision is making a problem. As always, RCN used to be Carmel, New York, Putnam County, and quite a few in Dutchess. Greenberg, Mamaroneck, Manchester, Connecticut. No. There's still a solution to that. We've got to listen. Find out what it is. Poughkeepsie, Trenton, New York, Wappingers Falls, Albany, Bergen, Wingdale, Litchfield, Binghamton. Maureen Shepard, have you sent in your renewal in Litchfield? Binghamton, oh, that's Ken Harris. Love Ken Harris. No Knoxville, no Columbia. Middletown, New York, yes. Chatham, New York, yes, yes. DC TV and the internet.
This is the edit box. This is the terribly expensive and burdensome QPTV dumb board. QPTV making us use professional Sony DV cam. They're awfully cute. Let me open one up for you. They're cute. That's a little videotape. But very, very expensive. And it's a crooked thing that Sony does. They keep changing the format, and that's the only way they can make money. And then the QPTV gets paid off, and so they go along with it. This is, these are tapes that have George McDermott footage on it, and I wanted to get George McDermott on the TV. And I sent it to Cross River, but Walter Sands and Christine Savarino and Cecilia Mastorelli. By the way, pray for all three of those. They ruined everything. And they didn't get on Cross River. And I don't know where they are at the moment. They're my tapes. I wanted to pick them up, and they won't give them to me. It's my property, and they won't give it to me. Did you ever hear of anybody as dumb, arrogant, and ignorant as Cablevision? And so Zeke Hunter, I haven't had a chance to call him to see if he can get down and get them. Poor Zeke. He says, this is getting to be a pain in the neck. And I said, yes, Zeke, that's exactly what they want to do. They want to pressure you into quitting. Zeke says, well, I'm not quitting. Okay. Now, so, wrapping is done. 41 videotapes are wrapped. And we didn't buckle under this. There was a pressure. This thing has to get out today. And here it is. This is Glendora versus Nasty Natalia. This is an entire file. And it was this plus this, but I got it down to this. And this is the record on appeal, the docket, the noticing the appeals court that the appeal is ready to be argued, and then something that's a very big surprise. Now this has taken 9 hours so far, and I thought we'd have to buckle and give up wrapping the tapes to do this. But we didn't. We persevered wrapping the tapes, alternating wrapping 10 tapes at a time, with working an hour on this Herculean double cross of the United States of America, Glendora versus Nasty Natalia, Brat's sister Lydia, mother Marie, father, brother Carlos, preferred country properties, James Kleinbaum, George Dixon, Joanne Dixon, the village of Chatham, New York, and the Chatham Police Department. So this has to get out today. This is a Monday morning job. See, all during the week, I put down the date, and if it's postage, or if it's printing, or if it's one